Greetings students, I hope that you're all doing fine. In this lecture, as we all know, we're going to continue with bailment and planche. So let's start. Starting with the rights of bailee, at the very offset we see that the first right that the bailee has is that of compensation. As mentioned under section 164, bailor's responsibility to bailee. The bailor is responsible to the bailee for any loss which the bailee may sustain by reason that the bailor was not entitled to make the bailment or to receive back the goods or to give directions respecting them. If the bailor has no right to bail the goods or to receive them back or to give directions respecting them, and consequently the bailee is exposed to some loss, then the bailor is responsible for the same. Now, students, such sections of which I do not share much information, of which I do not share with you many case laws, and I basically paraphrase the idea that is mentioned in the definition of the section. Such sections are those sections which are not as important and will most likely not be asked in the PCSG examination, and this is the reason why I keep them short. And I want your attention to be focused on areas which are much more important. So please cooperate and give only as much attention to such areas as they deserve. Now, the second right is that of expenses or remuneration. So, section 158 says that repayment by bailor of necessary expenses, whereby the conditions of the bailment, the goods are to be kept or to be carried or to have work done upon them by the bailiff or the bailor, and the bailee is to receive no remuneration, then the bailor shall repay to the bailee the necessary expenses incurred by him for the purpose of the bailment. A bailee is entitled to recover his agreed charges, but where there is no such agreement at all, section 158 comes into play. The section says that where the bailee is required by the terms of bailment to keep or carry the goods or to do some work upon them for the benefit of the bailor, and the contract provides for no reward, the bailee has a right to ask the bailor for payment of necessary expenses incurred by him for the purpose of the bailment. The Calcutta High Court has laid down in the case of Surya Investment Co. versus State Trading Corporation of India that this right is not linked with the right of lien. Lien can be exercised only as long as possession is retained, whereas the right to charges remains alive even when possession has been parted with. In this case, the State Trading Corporation had hired the plaintiff's storage tank for storing its oil, and on account of a dispute, the STC appointed a special officer who took charge of the tank and delivered its content to others as directed. The plaintiff thus lost possession of the oil and with its lien, his right to charges for protection and storage of the oil survived. So the court said that the bailor had enjoyed the benefit of the bailee's services. Now the third right is that of lien. Yes. If the bailee's lawful charges are not paid, he may retain the goods. The right to retain any property until the charges due in respect of the property are paid is called the right of lien. Liens are of two kinds, namely particular lien and general lien. As a general rule, a bailee is entitled only to particular lien, which means the right to retain only that particular property in respect of which the charge is due. This right is provided for in section 170 of the Act. Bailee's particular lien, where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. Now it has some illustrations where A delivers a rough diamond to B, a jeweler, to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for the services he has rendered. A gives cloth to B, a tailor, to make into a coat. B promises A to deliver the coat as soon as it is finished and to give a 3 months credit for the price. B is not entitled to retain the coat until he is paid. Now, hitting the area of exercise of labor or skill as mentioned in the definition. So we see that the right is available subject to certain important conditions. And as held in Bailment versus Waters, the foremost among them is that the bailee must have rendered some service involving the exercise of labor or skill in respect of the goods bailed. Further, in Hutton versus Car Maintenance Court, the owner of a motor car gave it to a company to maintain it for 3 years on a fixed annual amount. An amount having become due for maintenance charges, the company claimed lien on the car. So it was held that inasmuch as what the company did was not to improve the car but only to maintain it in its former condition, the company had no lien on the car. Now, talking about the area of possessory right, we see that the right depends on possession and is lost as soon as possession of the goods is lost. So, in Edgley versus Cafe John Bros, where the plaintiff purchased an old refrigerator, the vendor agreeing to repair it for a fixed charge, and when the repair was over and the condition of the machine was found satisfactory, it was delivered to the plaintiff, but a part of the repair money was still unpaid. The machine broke down again, and the vendor carried its engine and other parts for further repairs and claimed lien on these parts until the outstanding charges of repair were paid. So in this case, the court held that delivery of possession after repairs are effected puts an end to the lien which the repairer has for the charges of repairs and cannot be revived because the repairer undertakes further repairs mainly out of grace and not as a matter of fresh contract. Now, coming to general lien. The right of general lien, as we see, is provided under section 171, and it means the right to hold the goods bailed as security for a general balance of account. The right of particular lien entitles the bailee to retain only that particular property in respect of which the charges are due. But general lien entitles the bailee to retain any goods bailed to him for any amount due to him, whether in respect of those goods or any other goods. If, for example, two securities are given to the banker, but a loan has been taken only against one of them, then the banker may retain both securities until his dues are paid. In Jowett and Sons was a Union Cold Storage Co., where a quantity of imported meat was stored with a warehouse keeper who, by a general term of the trade, had a general lien. It was held that he could retain the meat for his charges due in respect of other goods. Thus, Section 171 says general lien of bankers, factors, warfingers, attorneys, and policy brokers. Bankers, factors, warfingers, attorneys of a high court, and policy brokers may, in the absence of a contract to the contrary, retain as a security for a general balance of account any goods bailed to them, but no other persons have a right to retain as a security for such balance goods bailed to them unless there is an express contract to that effect. So, following are the types of lien covered by this given act. Number 1, lien of finder of goods as mentioned under section 168. Number 2, Bailey's lien, under which particular lien lies under section 170 and general lien lies under section 171. Number 3, lien of pledge or pawning as mentioned under section 173 and 174 as we will discuss. And number 4, lien of agents once again which we will discuss as mentioned under section 221. Now, coming back to the rights as we were continuing, right to sue is the fourth one here. So, section 180 says sued by bailer or bailee against wrongdoer. If a third person wrongfully deprives the bailee of the use or possession of the goods bailed or does them any injury, then the bailee is entitled to use such remedies as the owner might have used in the like case if no bailment had been made. And either the bailer or the bailee may bring a suit against a third party for such deprivation or injury. Section 181 says apportionment of relief or compensation obtained by such suits. Whatever is obtained by way of relief or compensation in any such suit shall, as between the bailer and the bailee, be dealt with according to their respective interests. It has been held in the case of Karnataka Electricity Board vs. Halappa that Section 180 enables a bailee to sue any person who has wrongfully deprived him of the use or possession of the goods bailed or has done them any injury. The bailee's rights and remedies against the wrongdoer are just the same as those of the owner. An action may therefore be brought by the bailee or the bailer. Whatever is obtained by way of relief or compensation in any such suit shall, as between the bailer and the bailee, be dealt with according to the respective interests. For example, in the case of Purushottam Das Banarsi Das versus Union of India, where the railway company was induced on production of forged railway receipts to deliver certain goods, the company was held entitled as a bailee to sue to recover the goods from a person with whom they were subsequently pledged. Now, Coming to the area of pledge, Section 172 mentions pledge, pawner, and pawnee defined. The bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer is in this case called the pawner. The bailee is called the pawnee. So, a question has been asked in UPPC's examination 2015. In the law of contract, bailer in pledge is called, and as we would go on to learn, it is called pawner. Bailer in pledge is pawner. Now, a pledge is only a special kind of bailment, and the chief basis of distinction is the object of the contract. It is important to remember this idea. As seen in London Prasad versus Rahmat Ali, where the object of the delivery of goods was to provide a security for a loan or for the fulfillment of an obligation, that kind of bailment was called pledge. So, pawn or pledge is a bailment of personal property as a security for some debt or engagement. A pawner is one who, being liable to an engagement, gives to the person to whom he is liable a thing to be held as security for payment of his debt or the fulfillment of his liability. Now, talking about the essential characteristics of a pledge. At the very offset, we have delivery of possession. So, delivery of the chattel pawned is a necessary element in the making of a pawn. The property pledge should be delivered to the pawnee. Thus, in Revenue Authority versus Sudarshanam picture, where the producer of a film borrowed a sum of money from a financier distributor and agreed to deliver the final prints of the film when ready, the agreement was held not to amount to a pledge, there being no actual transfer of possession. So there is also pledge by hypothecation, because sometimes the goods are allowed to remain in the custody of the pledger for a special purpose, but that does not militate against the effectiveness of the pledge. In Peace versus Capper, we see where the captain of a ship pledged his chronometer with the ship owner, who allowed him to use the instrument for the purpose of a voyage. The captain pledged it over again with another person. So the question that we saw was whether the pledge was valid. That is the first pledge, whether it was valid or not. And the court held that it was. In the same way, a constructive pledge comes into existence as soon as the pawner, without actually delivering the goods, agrees to hold them for the pawnee and promises to deliver them on demand. Now, the second essential is that it has to be in pursuance of contract. As held in Blundell versus Attenborough, pledge is a conveyance pursuant to a contract, and it is essential to a valid pledge that delivery of the chattel shall be made by the pledger to the pledgee in pursuance of the contract of pledge. So, it is not necessary at the same time that delivery of possession and the loan should be contemporaneous. That is, it is not necessary that both the delivery of possession and the loan should be in parity. As held in Lallan Prasad versus Rahmat Ali, delivery and advance need not be simultaneous, and a pledge may be perfected by delivery after the advance is made. Now that we have considered the essential characteristics of a pledge, let's talk about the rights of pawnee. So, the first right is that of retainer. As mentioned in Section 73, pawnee's right of retainer. The pawnee may retain the goods pledged not only for a payment of the debt or the performance of the promise, but for the interest of the debt and also for all necessary expenses incurred by him in respect of the possession or for the preservation of the goods pledged. For the Section 174 mentions that pawnee not to retain for debt or promise other than that for which goods pledged. Presumption in case of subsequent advances. The pawnee shall not, in the absence of a contract to that effect, retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged. But such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the pawnee. As held in Alliance Bank of Shimla versus Ghatnandi Lal Jain Lal. The first important right of a pawnee is the right to retain the goods pledged until his dues are paid. He has a right to retain the goods not only for payment of the debt or for performance of the promise, but for the interest due on the debt, and all necessary expenses incurred by him in respect of the possession or for the preservation of the goods pledged. The pledgee can retain the goods only for the payment of that particular debt for which the goods were pledged and not for any other debt or promise unless there is a contract to the contrary. In Kawasji Muncharji Banaji versus Official Assignee of Bombay, where, however, after a pledge was created and subsequent advance was made without any other security, a contract to burden the same goods was presumed. Further, as held in Bank of New South Wales versus O'Connor, the right of retainer ends on proper tender of payment. If the pledgee refuses a proper tender, he opens himself up for pledge's remedy of seeking return and absolute liability of bailey under Section 160 and Section 161 for failure to return in time. Now, talking about special and paramount interest of pledgee, we see that the right of retainer is thus in the nature of a particular lien. Yet, lien is different from pledge. A pawn or pledge is an intermediate between a simple lien and a mortgage, as held in Servopori Instruments Limited versus Soma Textile Industries. The pawnee gets a special property in the goods pledged. The general property remains in the pawner and wholly reverts to him on discharge of the debt. The right to property vests in the pledgee only so far as is necessary to secure the debt. Now, we also have cases where hypothetically Now, we also see that the hypothecary has no direct right of seizure. Where the pledge is by way of hypothecation, the creditor cannot directly seize the goods by entering premises or otherwise. He has to do so either with the consent of the borrower or through a court order. The creditor does not have the right to enter the premises, lock and seal the same. In Union of India versus Shanthila Nathan, the most conspicuous In Union of India versus Senthili Nathan, the most conspicuous feature of the agreement was that in case the borrower committed default in payment of the debt as stipulated, the lender was at liberty to seize the goods. The court held that this power was not directly exercisable. No possession was delivered on the date when the hypothecation deed was entered into. What was contemplated was a future overt act on the part of the creditor to sequester the goods if so desired, and that too by a process known to law. At best, the right which the plaintiff had under the agreement was to file a suit on the dead and after obtaining a decree to proceed against the property specified in realization of the decree. Now, the second right is that of extraordinary expenses. Yes, the pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged. For such expenses, however, he does not have the right to retain the goods. He can only sue to recover them. And this right is provided under Section 175, which says Pawnee's right as to extraordinary expenses incurred. The pawnee is entitled to receive from the pawner extraordinary expenses incurred by him for the preservation of the goods pledged. In Syndicate Bank versus Mahalakshmi Ginning Factory, in an agreement of term loan and hypothecation with the bank, there was no provision empowering the bank to debit any amount by way of Xerox charges or legal fee. The court here did not permit the bank to debit such amounts. Now, coming to the third right, that is right to sell. As mentioned under Section 176, pawnee's right where pawner makes default. If the pawner makes default in payment of the debt or performance at the stipulated time of the promise in respect of which the goods were pledged, then the pawnee may bring a suit against the pawner upon the date of promise and retain the goods pledged as a collateral security, or he may sell the thing pledged on giving the pawner reasonable notice of the sale. And if the proceeds of such sale are less than the amount due in respect of the debt or promise, then the pawner is still liable to pay the balance. If the proceeds of the sale are greater than the amount so due, the pawnee shall pay over the surplus to the pawner. As held in SK Engineering Works versus New Bank of India, upon a default being made by the pawner in the payment of the debt or performance of the promise, the pledgee gets two distinct rights under Section 176 of the Act. Firstly, the pledgee may sue upon the debt and retain the goods as a collateral security. And secondly, he may sell the goods after reasonable notice of the intended sale to the pawner. Further, it was laid down by the Supreme Court in Lalnan Prasad versus Ahmed Ali that the right to sue is a personal action and rests upon the contract of loan quite apart from the pledge. But until the money due is recovered, the pledged goods may be retained, though they would have to be surrendered when the loan is realized. If, by reason of his own act, the pledgee is unable to return the goods, he cannot have judgment for the debt. So we see that the two rights are disjunctive. It has been held in KM Hidyatullah versus Bank of India that the pawnee's two rights, namely the right to sue the pawner for personal recovery or resort to sell the security after reasonable notice, are disjunctive, being independent of each other. The fact that a period is prescribed for filing suit would not mean that the prescribed period would also apply to the alternative remedy of selling the goods. Now, talking about pawner's right to redeem, as seen in section 177, that is defaulting pawner's right to redeem, if a time is stipulated for the payment of the debt or performance of the promise for which the pledge is made, and the pawner makes default in payment of the debt or performance of the promise at the stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them, but he must, in that case, pay in addition any expenses which have arisen from his default. Again, as held in Lallan Prasad versus Rahmat Ali, satisfaction of the debt or engagement extinguishes the pawn, and the pawnee on such satisfaction is bound to re-deliver the property, and the pawner has an absolute right to redeem the property pledged upon tender of the amount advanced. So, student, by now you must have been able to understand that this Lallan Prasad case is very important. Please double mark it. Where the pawner redeems after the expiry of the specified time, he is bound to pay to the pawnee such expenses as have arisen on account of his default. As held in Hotel Vrinda Prakash versus Karnataka State Financial Corporation, where the pawner redeemed before the expiry of the specified period, he would remain bound by the terms of the loan, if any, that a premium would be leviable on premature repayment. Now, talking about legal heirs' right to redeem. So for that, we have the authority of Kamali Sarjani versus Indian Bank, where certain gold ornaments were pledged with the bank as security for gold loan, and the pawner died, and he left behind a will enabling his widow to redeem. The bank demanded probate, and it was held that the bank had no right to do so. Neither probate nor succession certificate was necessary. The son and daughter of the deceased had raised no objection. Now, coming to another important area, that is who can pledge. So, ordinarily, goods may be pledged by the owner or by any person with the owner's authority, and a pledge made by any other person may not be valid. Thus, for example, in SBI versus Manglabai G. Deshmukh, where goods were left in the possession of a servant while the owner was temporarily absent, a pledge made by the servant was held to be invalid. Section 178 and 179 provide for certain circumstances in which a person being left in possession with the consent of the buyer may make a valid pledge, though without the owner's authority. So, the first given case is that of pledge by mercantile agent. Section 178 says, pledge by mercantile agent, where a mercantile agent is, with the consent of the owner, in possession of goods or the documents of title to goods, any pledge made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the pawnee acts in good faith and has not at the time of the pledge noticed that the pawner has no authority to pledge. Now it has an explanation that in this section the expressions mercantile agent and documents of title shall have the meanings assigned to them in the Indian Sale of Goods Act of 1930. So the first exception is in favor of a pledge created by a mercantile agent. Section 178 provides that where a mercantile agent is, with the consent of the owner, in possession of goods or document of title to goods, then any pledge made by him while acting in the ordinary course of business shall be valid, provided that the pawnee acts in good faith and has no notice of the fact that the agent has no authority to pledge. The necessary conditions of validity under the section are as follows. Number one, mercantile agent. That is, there should be a mercantile agent. The explanation to the section says that the expression mercantile agent has the same meaning as is assigned to it by the Indian Sales of Goods Act of 1930. And in this act, mercantile agent means an agent having in the customary course of business as such agent authority either to sell goods or to consign goods for the purpose of sale, or to buy goods or to raise money on the security of goods. This is what is mentioned under subsection 2(9) of Sale of Goods Act. Now, the second condition is that of possession with owner's consent. The mercantile agent should be in possession of the goods or documents of title with the consent of the owner. The Supreme Court has laid down that the word consent for this purpose means agreeing on the same thing in the same sense as defined in section 13 of the Indian Contract Act. If the consent is real, it is immaterial that it was obtained by fraud or misrepresentation or with dishonest intention. All these things may make the person receiving possession liable for some offense, but the consent of the owner actually given is not annulled thereby. Thus, in the case of U. Suleiman versus M.A. Yuvat, where a goldsmith obtained possession of certain jewelry under the pretense that he had a customer and instead pledged the jewelry, the pledgee was held to have obtained a good title. Now, the third condition is that it should be in the course of business. So goods should have been entrusted to the agent in his capacity as a mercantile agent, and he should be in possession in that capacity. As seen in Staff Motor Guarantee Limited versus British Wagon, if the goods are entrusted to him in a different capacity, it is not open to a third party who takes a pledge from him to say that they were in his possession as a mercantile agent and therefore he had the power to create a pledge. The fourth condition is that of good faith. Yes, the last essential requirement is that the pawnee should act in good faith and should not have at the time of the pledge notice that the pawner has no authority to pledge. The expressions good faith and notice are not defined in the Act. The definition of good faith, as given in the General Clauses Act of 1995, is therefore applicable. And according to that Act, a thing is said to be done in good faith when it is done honestly, whether negligently or not. Now, talking about pledge by documents of title. So, where a mercantile agent is in possession of the documents of title relating to his principal's goods, and if he pledges the same, the pledgee gets a good title if he acts in good faith and without notice. As an explanation to section 178 says that the expression documents of title shall have the same meaning as is assigned to it in the Sales of Goods Act of 1930. Subsection 2(4) of this Act provides that documents of title to goods includes a bill of lading, dock warrant, warehouse keeper's certificate, wharfinger certificate, railway receipt, warrant, or for the delivery of goods, and any other document used in the ordinary course of business as proof of the possession or control of goods, or authorizing or purporting to authorize, either by endorsement or by delivery, the possessor of the document to transfer or receive goods hereby represented. Now, coming to the second area, we had started with this thing that there was a pledge by a mercantile agent in which there were four conditions. Now, coming to the second broad area, that is who can pledge. The first one was pledged by a mercantile agent, and the second one is that pledge that a person in possession under voidable contract. That is what section 178 says, that a person should be in possession under voidable contract. It says that pledge by person in possession under voidable contract when the pawner has obtained possession of the goods pledged by him under a contract voidable under section 19 or section 19A, but the contract has not been rescinded at the time of the pledge, then the pawnee acquires a good title to the goods provided he acts in good faith and without notice of the pawner's defect of title. So, where goods are pledged by a person who has obtained possession under a voidable contract, the pledge is valid provided that the contract has not been rescinded at the time of the pledge and the pledgee has acted in good faith and without notice of the pledge's defect of title. On that note, the case of Phillips versus Brooks Limited is a well-known authority. Here, a fraudulent person pretending to be a man of credit had induced the plaintiff to give him a valuable ring in return for his check, which proved worthless. Before the fraud could be discovered, the ring was pledged with the defendants. So, in this case, the pledge was held to be valid, it being made by a person in possession under a voidable contract. The effect of fraud is to render the transaction voidable and not void. And if therefore an innocent person has taken the goods under a pledge before the transaction is avoided, then the true owner cannot claim them back. Now, the third category under who can pledge is that of pledge by pledgee. So, section 179 says pledge where pawner has only a limited interest. Where a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that interest. Section 179, which is the relevant provision, says that where a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that interest. Thus, as seen in Firm Thakur Das versus Mathura Prasad, when a pledgee further pledged the goods, the pledge was held to be valid only to the extent of his interest, and his interest was the amount for which the goods were given to him as a security. If he pledges for a larger amount, the original pledger will still be entitled to his goods on paying the amount for which he himself pledged the goods. Now, there are some additional exceptions under the Sales of Goods Act, and in addition to these exceptions, the additional exceptions are mentioned under Section 30 subclause 1 and Section 30 subclause 2 of the Sales of Goods Act 1930. It says that a pledge by a seller remaining in possession after sale and by a buyer obtaining possession before sale is valid. And these two are very important provisions to remember. And lastly, it has been held in Shadi Ram versus Mehtab Chand that where one of several joint owners is in possession with the permission of all, a pledge by him would be valid if the buyer had no notice of the situation. And that sums up this lecture. Now I hope that you will be able to answer any question that comes from this given topic. Till we see each other again, take care.